Welcome all to the class of Classification of Administrative Action for Administrative Law by Dr. K. Sangeeta. In 21st century, various functions are performed by administrative entities so much as to administrative process across the traditional bounds of classification and combines it into an power exercised by all the organs, which is legislative, executive and judiciary, which are the three wings of the government. It's evident that the wide variety of activities fall within the sphere of administrative action. Even administrative authority doesn't restrict to courts and legislative bodies of the country. Residuary functions of administrative body may themselves partake to the legislative or a judicial quality. The consideration that arises is whether the function performed by the executive authority is purely administrative, quasi-judicial or quasi-legislative in its nature, since there is no precise or scientific test to distinguish one from another. Classification is essential and inevitable as many consequences flow from it. Example, if an executive authority exercises judicial or quasi-judicial function, it must conform with the principles of natural justice, or it must be amenable to certiorari or prohibition. But it's an administrative, legislative or quasi-legislative function. That's not the case. It is therefore imperative to determine what type of function the administrative authority is performing. Classification of administrative action is necessary to determine the scope of the effect of judicial and legislative power on administrative action, such as judicial review of administrative action is less restricted as compared to the legislative action. Mandamus cannot be issued against an executive body with respect to its legislative action. General sentiment among legal writers and lawyers is that attempt made on clarifying administrative law is not merely impossible but also redundant. Even a student of administrative law is made to delve into this classification, since there is a complex amalgamation of the three wings of the government and the projection of one wing on the other. Broadly speaking, administrative action can be classified into three groups: quasi-legislative or rule-making action, quasi-judicial action or rule decision action, or purely administrative action or rule application action. Understanding classification in detail. Legislature is the lawmaking branch of the state. Unlike constructions like Australian Constitution or an American Constitution, wherein this power has been explicitly demarcated, the Indian Constitution doesn't have express provision for the same, through the intention of the Constitution makers, which remind that the legislative power should be exercised by those in whom it is vested. The same cannot be fructified in lieu of efficient working of the intensive form of the modern government. Therefore, delegation of power to administrative body is a necessity. When any administrative body exercises the lawmaking power delegated to it, it is known as the rule-making action or quasi-legislative action. When an instrument of legislative nature is made by way of delegated power, it is called subordinate legislation, being subordinate in the sense that the powers of the authority are limited by the statute which are conferring these powers. Quasi-legislative action is the function of a subordinate legislation making rules, regulations or other statutory instruments to fill in the details of legislative enactments in order to make the execution of the laws possible. It is imbibed in itself the characteristic which a normal legislation possesses. According to Chinnappa Reddy, a legislative action has four features: generality, prospectivity, public interest, rights and obligation flowing from it. These features help to distinguish quasi-legislative action from a quasi-judicial action. However, in certain cases, it is not easy to differentiate. In the case of Express Newspaper versus Union of India, the Supreme Court kept the question whether the function of the Wage Commission under the Journalists' Condition of Service Act 1956 is a quasi-legislative or a quasi-judicial was left open. However, the power to fix the price of sugar was held to be quasi-legislative. Therefore, it can be understood that the task of differentiating between legislative and administrative action is very difficult, and the theory is impossible in practice. If a particular function is termed as rule-making instead of judicial, it can have substantial effect upon the parties concerned. There is no right of being heard before the making of a legislation, whether primary or delegated, unless provided by a statute itself. Since these actions are controlled by Parliament and the courts, and as under Article 14, equality applies to these actions as well. Quasi-judicial action. Majority of the decisions which affect individual or private bodies come not from administrative agencies. Since administrative decisions making it is a byproduct of intensive form of government, the traditional judicial system falls short in giving quantitative and qualitative judgments required in the welfare state. Some jurisdictions use the term quasi-judicial to describe administrative adjudicatory or decision-making process. However, since the term quasi-judicial is somewhat vague, it's difficult to define and thereby fall into disuse. Administrative decision-making may be defined as a power to perform acts administrative in nature but requiring some judicial characteristics. On the basis of various administrative functions, it has been held that to be quasi-judicial by various courts. Disciplinary action against student, disciplinary proceedings against an employee for misconduct, confiscation under C Custom Act 1878, cancellation, suspension, revocation or refusal to renew license or permit, determination of citizenship, deciding statutory dispute, power to continue detention of seized goods beyond a certain period, refusal to grant NOC under Bombay Cinema Regulation Act 1953, forfeiture of pension and gratuity, granting and refusing permission for retrenchment, grant of permit by Regional Transport Committee. Donoughmore Committee on Ministers' Power in 1932 had attempted to analyze the attributes of a true administrative action. The committee was of the view that a true judicial decision presupposes the list between two or more parties and then involves first, presentation of the case, second, ascertainment of evidence, third, submission of legal arguments, and lastly, decision which disposes of the whole matter by applying law, analyzing the evidence of the case. A quasi-judicial action involves the first two elements, which may involve the third but never the fourth. Decisions which are administrative stand on wholly different footing from a quasi-judicial or a judicial decision, since in case of administrative action, there is no legal obligation to consider and weigh submission or collect evidence or pass judgment. The entire discretion is left to the administrative authority. However, this approach of the committee seems problematic because judges cannot be regarded merely as law-producing machines.